Hello friends, welcome to Shri Rounds. The topic for today's discussion is Maratha Reservation case. How to identify socially and educationally backward classes. Backstory. The Supreme Court recently held that Maratha Reservation in Maharashtra to be unconstitutional for violation of equality and breaching the 50% cap on reservation. By a 3:2 majority, it also ruled that the states do not have the power to identify socially and educationally backward classes. What was the 102nd Amendment? The 102nd Constitutional Amendment made three significant changes to the Constitution. First, it created a National Commission for Backward Classes with constitutional status. Second, it specified a process for the identification of SEBCs. Third, it added a new subclause to the Constitution's definitions clause in Article 366, which stated the term SEBC means such backward classes as are to be deemed under Article 342A for the purposes of the Constitution. What did the new Article 342A say? It said that the President shall notify a list of SEBCs in relation to each state and union territory in consultation with governors of the respective states. It further said that once this central list is notified, only Parliament could make inclusions or exclusions in the list by law. What was the provision in litigation? One of the challenges to Maratha quota was creating the quota through a new category called SEBC was unconstitutional because after the introduction of the 102nd Amendment, the state legislature had no power to identify any new backward class. What is the current method for identification of SEBC? According to the status quo, the centre and states exercise joint and separate powers to identify SEBCs through central list and state lists for their own purposes, such as for educational institutions and public employment. What did the Union argue in this context? The Union government argued that it was never its intention to deprive state governments of their power to identify SEBCs. It said Parliament's intent was only to create a central list that would be applied only in central government and its institutions. How did the court reach this ruling? The court adopted a literal interpretation of the 102nd Amendment, and the majority held that the text was clear that the President alone could notify the list and subsequent changes could be made only by Parliament by law. They also held that since the text was a mirror image of provisions governing identification of scheduled caste, the Parliament intended to replicate the same process for backward classes too. What did the dissenting judges hold? The minority accepted Union government's position that it was never its intention to deprive states of their powers. They held that the central list was only for use by the centre in reservation for jobs and institutions under the Union government and will not apply to states. What are the arguments against court's ruling? Legal scholar Gautam Bhatia has argued that there was one notable difference between provisions regarding SC and ST under Articles 341 and 342 respectively on the one hand, and Article 342A on the other. In their second subclauses, Article 341 and 342 clarified that a presidential notification could only be amended by the Parliament. Article 342A, Clause 2, however, mentioned that the Parliament can amend central list of the SEBC. Why is the word central list relevant? The relevance of central list is new and strongly indicates that the new constitutional arrangement was limited in its operation to the existing process only at the central level, that is with respect to central list of SEBCs and not the state lists. Well, that's all for today. I hope you enjoyed today's podcast.